Hello, my name is Shannon Riley, and this is my timeline on the history of special education law. My timeline is going to go from the Brown versus Board of Education in 1954 through the current IDEA law that we currently follow in schools today. An important question to ask is, why do we have special education in schools today? And when you look back in history, the real answer to that is because we have laws. We have laws that are in place to protect children and their families, parents, with disabilities. The first case that I'm going to talk about is in 1954, and that is the famous Brown versus the Board of Education. It was a famous civil rights case that was to prevent discrimination in education. This case was all about racial segregation in the public schools. And what I mean by that is, at this time in 1954, we had schools, and prior to this, schools that were white schools and schools that were black schools. So the students didn't integrate. If you were black, you went to the black school. If you were white, you went to the white school. And the students began to argue that segregated schools were unequal and that they deprived them of the same education as the white students. So the Supreme Court found that African American children had the right to an equal education opportunity, and that segregated schools had no place anymore in the field of public education. So on May 17th of 1954, Chief Justice Earl Warren read the decision of the unanimous court. We come then to the question presented: does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal education opportunities? So what he's saying here, though, is a lot of people's arguments were, hey, they have a school building, we have a school building, so they're equal. Well, what the judge here is trying to say is, even though that they have each their own place, it's still not equal, and their decision was that they believed that it did deprive them. The court also stated that segregation based on unalterable characteristics, which meant that, they couldn't change their color of their skin. So with the result being inequitable opportunities, could not be upheld in the United States, and demanded that such segregation end in all deliberate speed. So that was their decision, and it was to take place immediately. It's important to note that in the Brown versus Board of Education case, that this case had nothing to do with special education, but it did set the precedent for future discrimination cases in education, including special education. What we found after this case, though, was that parents with children that had disabilities began to bring lawsuits against school districts for excluding and segregating their children. Remember, we talked about that in the Brown case, that the fight was that they couldn't change the color of their skin. Well, the parents of children with disabilities were saying that, hey, we can't change how our child is. So they argued that the schools were discriminating against their children because they had a disability. There we enter into the 1960s, and of course this was huge civil rights. So people were fighting, many groups of people were fighting for their rights. And so we see that the people with disabilities were fighting for their rights. And one of our first advocates of disabilities was President John F. Kennedy. Of course, he had a sister, Rosemary, who was born with a cognitive disability, and he believed that education was important for children with disabilities. And in 1961, he initiated the Presidential Panel on Mental Retardation. Here he said, we as a nation have for too long postponed an intensive search for solutions to the problems of the mentally retarded, and that failure should be corrected. Of course, we know that John F. Kennedy was assassinated, and his work for people with disabilities ceased with him. at that time because it wasn't a priority for President Johnson. But one important thing did happen in the 60s after his death was that his sister, Eunice Kennedy Shriver, she became an advocate for people with disabilities, and in 1968 she founded the Special Olympics, which was an organization dedicated to celebrating people with disabilities through sport events or as athletes. And today we have 2.5 million children and adults who participate in the Special Olympics in 180 countries. So that was a great thing that came out of it. But even though we saw great strides in the 1960s, we still had no laws. There were no laws to protect the rights of children, and many of children were still being denied the right for an education. And we move into the 1970s, and in the early 1970s, there were two significant court cases that would help change federal legislation protecting the rights of children with disabilities and their parents. These were two state cases, the Park versus Commonwealth of Pennsylvania and the Mills versus the Board of Education of District Columbia. In the Park case, it basically dealt with the exclusion of children with mental retardation from public schools. So they didn't really want them to be in the schools. They didn't know what to do with them, so they just excluded them. And the court mandated in the state of Pennsylvania that all students must be provided with a free and public education. So what the court was saying is, you know, hey, you can't deny them an education. Then we move into the Mills case, and that involved the practice of suspending and expelling and excluding children with disabilities. And the court held that no child eligible for publicly supported education in the District of Columbia public schools shall be excluded from regular public assignment. The District of Columbia shall provide to each child of school age a free and suitable publicly supported education regardless of the degree of the child's mental, physical, and emotional disability. The school's defense was that it just costs too much money. We can't afford it. We'd like to do it, but we can't afford it. And the court, of course, mandated the students with the disabilities receive special education services regardless of the school district's financial capability, stating that insufficient resources may not be the basis of exclusion. So both of these decisions would play an important role in the future of federal special education laws. But the good news was that, you know, we were starting to see some movement. Some of these parents going to courts and fighting for their children, but these were only state cases, and we still had no federal laws. But it did bring to Congress's attention, and they launched an investigation into the status of children with disabilities, where they found that millions of children were not receiving an appropriate education. So in 1973, they enacted the Rehabilitation Act, Section 504. And in the RA, it made discrimination against individuals unlawful against those who receive funds by federal subsidies and grants. So of course, all public school systems received federal subsidies and grants, so it made them have to comply with the Rehabilitation Act. So this was ensuring that students, or ensuring that students got an equal opportunity in all school activities, and it helped prevent discrimination against students with disabilities in federally funded programs. So this was a great start, but the problem was that the RA didn't have any specific laws. It didn't tell schools what they couldn't do or what they should do. So we still didn't have a federal law that was specific to special education. So in 1975, the congressional investigations also revealed that over 4 million children with disabilities in our country were not receiving appropriate educational services, and that number was staggering. Because of the lack of adequate services in the public school systems, families were often forced to find services outside of the public school systems, which was costing them money. And the Congress determined that this was unacceptable and that it was a national interest that the federal government step in and assist public schools to provide programs to meet the educational needs of children with disabilities. So on November 19th of 1975, Congress enacted into federal law the Education of All Handicapped Children Act. And it was signed into law by Gerald Ford, and it outlines the entire foundation upon which our current special education practices are today. This was the first law to clarify zero reject, which ensured that all students receive a free and appropriate public education, no matter how severe their disability. It required the school systems to include parents and guardians in their meetings and decision makings. It mandated an individual education program, or an IEP, which set short-term and long-term goals to ensure the necessary services were provided for that student. It required that students with disabilities be given non-discriminatory testing. It required due process procedures to be in place to protect families and students if there was a problem. So you had some legal ways of handling things. One of the important things to note when the first EHA came out was that it only covered school-age children, so that was from 6 to 21 years of age. Of course, with every law, as the years go by, it's necessary to have some amendments. So this EHA was reauthorized in 1986, 1990, 1997, and 2004. So we've had some revamps since then. The first one in 1986, it added the preschool and infant toddler programs, which meant they extended the purpose of the EHA to include children birth to 5 years of age. It established early intervention for infants and toddlers with disabilities. So this helped parents when they knew that, hey, there's something wrong with my child. They were able to get services before that child went to school. And it also added, instead of just IEPs, it implemented the Individualized Family Service Plan, which was IFSP. In 1990, the amendment was the name change, and it changed to IDEA, the Individuals with Disabilities Education Act. It also added autism and traumatic brain injury. That became its own classification, and it added transition services at the end, which basically, when a student graduates high school, the schools just said, bye-bye, good luck. This implemented that, hey, we need to come up with a plan for these students, so when they graduate high school, where they're going to go, they need to have some help with that transition into life. In 2004, the only change there was that they did change the name again. It still is pronounced IDEA, but now it's the Individuals with Disabilities Education Improvement Act. The good thing about IDEA is it mandates state and local accountability for the education of students with disabilities, and today all students with disabilities participating in state accountability systems. So what do we know about special education today? Where has it come, or what are the statistics now? And what we see today with all these implementations of laws is that 95% of students with disabilities are educated in general education buildings. Graduation rates for students with disabilities receiving a regular high school diploma has increased 43% in the past 15 years, with a 24% decrease in high school dropout rates with disability students. In the last 20 years, enrollment in 2- and 4-year colleges has almost doubled for students with disabilities, which is amazing considering that students weren't even considered to be educatable in the beginning. And more students with disabilities now hold jobs after leaving high school. So this is the end of my timeline, and I hope you enjoyed the information. Thank you.